and get on with things. My name is Richard Stevens. I've spent 40 years in practice as a solicitor, no longer. I am now earning my keep full-time as a trainer in commercial law subjects. So if you see anything you hear or like today, the way I go about doing things, then please feel free to get in touch with me and see if I can help you in your training. Now, Law Before Lunch, it's supposed to be short and sweet. No more than 20 minutes of your time. I look at one case or one issue that has some sort of resonance for practice. So without further ado, let me share my screen and let's crack on. I don't normally share the title screen, and I've called this one, the subtitle is Get It Right. Yes, get it right, because some people get it wrong. And I've had an argument about the principles involved in this case many times with solicitors, and many of them were wrong. This case, it doesn't tell us any new law. It just proves that I was right all along. It's a wonderful feeling, and I recommend it to all of you out there. And the case I want to talk about is Orion Shipping and Great Asia Maritime. And it looked at some of these wonderful things that we do. What is a condition versus a warranty versus an innominate term? I can never say innominate, so I always use the term intermediate. But anyway, innominate is out there. And the funny thing is, when I train junior lawyers these days, they're very often not taught, or if they were taught, they've forgotten, the distinction between a condition and a warranty. A condition you can terminate for even a trivial breach. A warranty you only get damages for. The modern law, of course, is that most terms are intermediate or innominate. It looked at this difference about how you terminate a contract. You can terminate a contract at common law for repudiatory or anticipatory breach. There are also contractual rights to terminate: insolvency, convenience, material breach. But crucially, if you do terminate a contract, what damages do you get? Because the way you terminate will determine what you get. In this case, there was a contract for the sale of a ship. There were delays in delivery. The arbitral tribunal crucially made a number of findings. The buyers had arrested the vessel, and that brought the contract to an end. That was a right of termination. The delay was due to the seller's proven negligence. Now, that's an odd expression, isn't it? And we'll see why they use that term in just a minute. But even more crucially, they found that the termination was not a repudiatory breach. It wasn't a breach that was so serious, went to the root of the contract, that it could be accepted at common law as discharging both parties from further performance. They awarded damages for the loss of the use of the vessel up to the point of cancellation, and that was not challenged. That was a fair award. But they also said that the buyer was entitled to cancel under a contractual provision we're just about to look at, and they awarded $1.85 million. And that was the difference in the market value of a substitute vessel and the contract price as at the date of termination. Now, those would be loss of bargain damages. That difference in value award is a loss of bargain award. What does that mean? We'll come to that in just a minute. The judge made a number of findings as well. Let's have a look at the clause. Should the sellers fail to give notice of readiness, blah, 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 by the defined cancelling date, then the buyers have the option of cancelling this agreement. And it goes on to say that they get their deposit back plus interest. So if the sellers are late again, haven't given notice of readiness, they will make due compensation to the buyers for their loss and all expenses together with interest, as long as the failure is due to the seller's proven negligence. That's where that odd expression comes from. Remember, the tribunal has found there was proven negligence, but it fell short of a common law repudiatory breach. So let's take a look at some law you should know. You only get loss of bargain damages following an accepted repudiatory breach. Okay, now this is crucial. So what are loss of bargain damages? Well, if you'll pardon me for saying so, they are the damages you get for the loss of your bargain. I know it sounds like a statement of the bleeding obvious, and in a sense it is. The damages you get for a contractual right to terminate for, say, material breach. would be the damage that flow from that particular breach. But the damages you get, as calculated in this case, for example, by the difference in value, going out into the market and buying substitute performance and then suing for that extra cost, they are damages for the loss of the bargain. They do not flow necessarily from the original breach. And you only get loss of bargain damages if you accept a repudiatory breach. I've had this argument, as I say, many times with commercial lawyers down the years, and lawyers get it wrong. Let's see a couple of examples where they got it wrong. Phones for You against EE. Phones for You, as you may remember, went belly up a few years ago. EE was suing them because they were no longer able to perform their contract with EE. So EE was suing for its loss of bargain damages. Their in-house lawyer wrote a letter terminating the contract as against Phones for You. And they relied upon the contractual ground of termination, which was insolvency. Absolutely right. Phones for You had gone into administration. That was fine. The judge went through a vast amount of case law. If you want to take a look at it and get up to speed in this area, please do. Vast amount of case law in a very long and detailed judgment. And he found that the lawyer, by having exercised the contractual ground of termination, had failed to exercise a right to terminate as at common law. And thereby, he had denied his client the right to sue for its loss of bargain damages. So the judge struck out EE's loss of bargain claim at summary judgment level. Funnily enough, I met a lady at an all-day training session I was doing last week, and she said she actually knew the lawyer who did that. And you'll be pleased to hear he is still in gainful employment as a lawyer, I should add. So it had, I think, a happy ending. Now, if you put in contractual rights of termination, material breach, insolvency, whatever it may be, you can, of course, say what you want to happen. So you could say nothing happens, in which case, as I say, if you terminate for material breach, you'd get damages for the immediate breach, but you wouldn't get loss of bargain damages. You could say that for termination for a material breach, the innocent party is entitled to all the damages it would have as if it had been a repudiatory breach. You could do that if you were careful enough in your drafting. Or you could say something else. Typically, the damages for delay are said to be exclusive. The exclusive remedy are liquidated damages. You could say that, for example. Let's take a look at James Kemble against K-Line. K-Line was contractually bound to make certain orders and place certain numbers of orders per year. And they said to James Kemble that they wouldn't be doing that in the following year. You can see the clause there. Either party can terminate if the other party commits a willful, persistent, or material breach of any provision and fails to remedy it within 30 days. Well, what the lawyers did there was they say, well, on behalf of James Kemble, we hereby give you written notice that we hereby terminate the contract pursuant to clause 11.3a. Well, that is it, material, willful, persistent, or material breach. It went on. You are in anticipatory, repudiatory breach of the agreement and have failed to remedy this within 30 days of our client's letter. This entitles us to terminate the service agreement, and we hereby terminate it. The judge was a little strict, and he said, well, it does refer to anticipatory, repudiatory breach, but it only purports to terminate under clause 11.3a. And what K-Line have done is that they've said that they are going to be in breach in the following year. So there isn't an existing willful, persistent, or material breach. Therefore, the purported termination under that clause is simply wrong. What they could have done, of course, is terminate for both reasons as a sort of scattergun approach. And the judge said this: I should make it clear that I reject James Kemble's submission that it would have been difficult or impractical to serve a notice that both purported to accept a repudiation at common law as well as purporting to rely on a contractual termination mechanism. Key sentence here: the serving of such notices without prejudice to the effect of the other is a well-recognized and used sentence. Similarly, the technique. Similarly, there would have been no difficulty in serving a notice under clause 11.3 that invoked different subparagraphs within clause 11.3 in the alternative. So what happened in the Orion shipping case? This is the shipping case, the sale of the ship. It had this strange clause in it saying that if it's due to proven negligence, you get due compensation. And what the judge basically said was, look, due compensation doesn't mean loss of bargain damages brought in through the back door. It means the compensation you would be entitled to depending on that particular type of termination that has taken place. So, for example, he said that would capture, for example, wasted expenditure, like if you had arranged to crew the vessel and the crew were sitting around on the dock side twiddling their thumbs, waiting for this delayed vessel to arrive. That's the sort of thing you could claim for a material breach, proven negligence, whatever you say. They could have got their loss of profits up to the point of cancellation of the contract. So you get the damages that flow from the failure to tender notice of readiness by the cancelling date. But what you can't do for a contractual termination is get damages for the loss of the contract as a whole, the loss of bargain damages. So let's have a look at some practice points here. First is, and this comment is addressed to you whether you are in private practice or whether you are an in-house lawyer. If your boss tells you to draft and serve a notice of termination, it is a hospital pass. It is a very dangerous area of the law, and I have given you some points that you need to take into account. It's not an exclusive statement of all the things you need to be considering when drafting that notice of termination. It reminds me of that great movie, Night of the Demon, which is all about, it was a 1957 B movie, which has since achieved cult status. And it was about a devil worship cult, and the way they would bump off their enemies was by passing a parchment to them that had on it magic runes. And your time allowed would be 3 days, after which the demon would appear from hell and crush you and tear you to bits. I was going to put it on the next slide, actually, the trailer from YouTube, but I was experimenting this morning and it was sort of a bit sort of choppy and the sound wasn't quite right, but there we are. So the first is never terminate a contract. If your client is getting into a long-term contract, you may as well say to them, you better be happy with the terms here because it's going to be very difficult to get out of this contract. If you are going to terminate a contract, get it right. And we've seen the point raised by this case, which is to adopt a scattergun approach, do it as broadly as possible, relying on every possible ground, each in the alternative, and without prejudice to the effect of the other. You need to get the right view on damages. And just remember that if you are going for those loss of bargain damages, you need to be alleging a repudiatory breach and making it unequivocally clear that you are accepting that. Or you need to be saying that there has been a breach of a condition. In a time clause, for example, the established way of doing that is to say, and time shall be of the essence. For example, you can use any words you like, but it has to be clear. The courts are leery of finding a condition. They mostly go for innominate or intermediate terms. You can specify the financial, etc., consequences in your cancellation termination clause, as I said, but you're not out of the legal woods yet. Because, of course, if you are providing for remedies over and above what the law provides, you're bringing yourself within the purview of the rule against penalties. And if what you're saying is that the guilty party is going to have to provide a remedy that is extravagant, exorbitant, or unconscionable, then that could be found to be a penalty. And that's another point that you should be advising your client on if you're going to be drafting that into your contract. If you're just putting in standard liquidated damages at the ordinary rate, the courts have made it quite clear that they are not keen to describe a penalty. That's fine. If you're saying that for a trivial breach, a relatively trivial breach, repudiatory damages might follow, well, there is a risk. There is a risk that a court may say that that is unconscionable, extravagant, exorbitant, and it comes within the rule against penalties and is unenforceable. Believe it or not, it takes longer to put together a short talk than it does to put together a long talk. So if you liked what you heard today, then you can certainly buy me a coffee. It's very nice if you do. You don't have to. Bear in mind, if you have any training requirements for in-house or if you're in private practice, very happy to talk to you about that. Other than that, I will take any questions